Hello and welcome back to the channel. Thank you for joining me in another of my wonderful interviews. Have you got a problem? Have you got a problem where, say, within the family, I don't know, a dispute over children, for example? Are you going to go to the court and try and work it all out? Is that something that worries you? Are you concerned of losing? What will happen if you lose? Are you nervous about the whole process? Well, I may have the gentleman for you today. His name is Dane, and he has written this remarkable book here called Family Law, A Layman's Guide. He's a gentleman who, he didn't want to have a lawyer. He knew the system was somewhat tilted in the favour of the judges and the courts and the bar guild and what have you. So he decided to use common law to make his way through. And he won at the High Court, as he says, under full discretion. Let's find out all about it and this rather interesting young man, Dane. Hello, Dane. Welcome to the show.
Hi, Richard. Thanks for having me.
It's an absolute pleasure. Now, you've written this book and you sent me a copy, which was very generous of you, and it's a beautiful book. What I found really interesting is that, as you say right at the beginning, this is a layman's guide. It's not legal advice as such, but you take us through a case in which you were trying to find the outcome to who is going to look after your child. You'd actually made an agreement beforehand, as I understand it, but then it became complicated and it had to go to court. And you went through the whole court process. You give us some transcripts of the whole court process with the judge and everything else, which is fascinating to read, and your common law approach to prevent them from getting jurisdiction the way they want it. And you win. So, Dane, tell us first of all then about how this came about.
Oh, yeah. So, just a normal, I used to have my daughter on the weekends, like most people would. She was living with her mum. And then we decided that she would live with me just for her own personal reasons. So she was living with me, and a couple of years later, her mum filed to the court for a residency order, which was a surprise to me because she was moving to America. Thus, the residency order was to have my daughter move to America with her.
Right, which would have been a huge shock to you.
Yeah, because at this time, my daughter was living with me based on our own agreement for her to live
and you're in the UK or
and I'm
England.
in the UK.
Yeah.
I'm in England. So then I just got the papers as anyone would do. Like you said, I didn't want to seek a lawyer, so I just started searching mostly online for information. I quickly found that there was no real information out there sharing about family law. They always direct you to lawyers and solicitors. I ended up going on YouTube, and I found lots of different information, and it was really hard to think which one to believe. I came across a particular channel. I came across a particular American guy who he had like a talk show channel, and I just listened to lots of the videos, and it just sounded so correct that I thought it must be true. It sounds so correct. It has to be true. So I started listening to more, and his approach was not giving a judge jurisdiction. And at the time, I didn't really know what that meant. And then so I made some phone calls with him. I had one-on-one phone calls with him, and he was just teaching me about the fact that, there's two different ways you can handle court. You have a legal capacity, as he said, and a private capacity. And ultimately, he taught me that your children are actually considered your property, which I know is really unnatural. And I was like, your property? Like, you can't go around saying that. People are going to think you're.
This is my property.
Yeah, exactly. It's not a natural way to refer to your children as. But he explained to me that property, the elements to property are if you create or author, which with your children you create your kids.
Of course, yeah.
If you
nobody else creates them for you, do they?
Exactly. If you maintain, so he who maintains, so you maintain your children. He who benefits, so you benefit from your children. So those are the elements, what we would say in the common law side that prove one's right to property.
Yes.
Because the legal side is just a title document, which is usually a deed document. So we're always on what some people think is equity or common law, but it's just what I would put under. It's just like a natural law of knowing of these are obviously the things that would consider your property. So he taught me lots of other things of how to not give a judge jurisdiction because one of the legal maxims is all are equal in law. So knowing that, the first point was to not stand up for the judge.
Right. Well, we hear that, we do hear this a lot, certainly on this show, where people say, you know, the first thing is as soon as they start telling you what to do, that is the point that you acquiesce to it, like stand up, all rise, and you stand up. You've stepped into their jurisdiction. You've tacitly agreed, and you don't know that.
Yeah, yeah. So we had like a little kind of role play of how the day might go from the point of, you know, when you step into the first thing that they do is, you know, all rise, stand up. The reason why you don't have to stand up is because if all equal in law, you know, if you stand up for another man who's allegedly your equal, then it looks like you're putting him at a higher status than you. So
Right.
that's the way that they perceive it.
Yes. And there's so much of the court is done by presumption and assumption.
Well, it's all done by presumption.
Yeah, exactly. Yeah.
As soon as you come with a fact, that leads the direction. So obviously this is actually part of the transcript in my book. So, you know, I didn't stand up for the judge. He got a bit upset with me. He's like, "You're not going to stand up." And, you know, part of the way to present yourself is to lack understanding, as we say. So, you know, I said, you know, I've never been to court. Are you meant to stand up? And he's like, "Oh, it's customary to." So I asked, "Am I required to?" Now, required was a legalese word, and it really means, do I have to by right and authority? So he said, "No, you're not required to. Please feel free to stay seated." Now, at this point, you know, I was like, "Oh my God, like, oh, this works, you know, it's going to work." And then we just continued to go forth. I guess the first main part that a lot of people would like to know in the private side or common law side is a lot about the name and not attaching yourself to the name. You know, a lot of people have heard that the legal name is not your name and actually the name of the, you know, the estate or the entity. So, you know, the judge then asks who's in court. He asked, you know, is Mr. and, you know, said my name. Now, I presented him with what we call a notice of special appearance, which is basically saying, you know, I'm Dane from the house of blah, 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 you know, appearing in court today at this time, you know, on this day. And I just gave that to him. I signed it and I had my thumbprint as my seal. So I passed it over to him.
So this was a prepared document that you took with you.
Yes, prepared. Yeah, it's just a little handwritten document that I prepared with me because that's now my defense as to presenting myself. You know, I'm not any of the names on your paperwork. This is my paperwork, and here's who I am. If you didn't know.
Yes, and you've got it on paper. It can go straight in front of him. He has now. It's part of the court record.
Yes, exactly. So when he asked me, "What do you mean you're not Mr.?" I said, "Well, I gave you my notice of special appearance, and my mother didn't call me Mr., nor do I have a prefix before my name. So I'm not referred to as Mr. If you are referring to me, please just call me, you know, Dane, as per my notice of special appearance." Then he changed his language and he said, "Oh, the respondent." And again, the respondent's a word that I don't know what that means. You know, it's got duties and liabilities, and I don't know how to act as a respondent. So I said, you know, I'm not a respondent. And he asked me what I mean again, because partly is you have to explain why you say what you say. I can't just say I'm not a respondent and not know why I'm saying that. So I said, you know, I don't know how to act as a respondent. If you're referring to me, I've given you my notice of special appearance. Please refer to me as Dane.
Yes.
So he just continued, you know, I guess that didn't give him a foot in. So he just continued, and we just continued back. He introduced the other party, and then we just went through the normal court process of her presenting her application because she was the applicant. So the applicant or the claimant always goes first. And then I presented, you know, my position, not an argument because we don't argue. Because if you create controversy, they get jurisdiction. So we don't.
Right. There's a lot to take in, isn't there, with all these things, because these are words that are commonly used, and unless you really have done your due diligence and know that, as you say, if you're making a complaint, then that's one of their terms. If you're raising a concern, that's one of your terms.
Yes,
and
exactly.
Things like that.
You've got to understand where, you know, because, you know, let's call it the private capacity and the legal capacity. The legal capacity is all of their rules and inside their jurisdiction. The private capacity is, you know, it comes with a different set of words, which are more, you know, more familiar with, and more basic. We don't complicate our words.
No.
They say things because, you know, they have their version of how things go, and I have my version of how things go. They have their version of how the language is used, and I have my version. They.
So, sorry to interrupt. I just wanted to go back. I mean, you're effectively arguing over who is going to look after another another well, a little girl. I'm having to choose my words because I was going
Yeah,
to say
yeah,
a
yeah.
child, and suddenly
I,
all these words
I
suddenly
think you
have
can use
different.
daughter. I think father, mother,
Daughter.
sons, and
There we are.
daughters.
That, yeah,
I think you can use
absolutely.
that.
So you're arguing about who is going to basically look after your daughter and where she's going to live and what country.
Yeah,
And this is obviously a huge decision that somebody else is actually making on your behalf, and so it's very brave, I would have said, to go in there against the system, swimming against the tide, but understanding what you believe to be true, which you had researched. How did you feel as you went through the process? We know now, you told us that you've won,
yeah.
but that the emotional turmoil of standing in this artificial theatrical land with people wearing gowns and wigs and all this sort of nonsense, it there to intimidate you, of course. How did you feel?
Oh, I was nervous, and I was not intimidated, but I was a bit scared because this could mean if the mother won, it's a big change for me, and it's not something
Yes.
that happens. So I was really scared that, oh, who are these people? Do these people really have the power just to take my child off me and tell them, dictate to me where she has to live if it's not with me? So yeah, I was really scared. I guess I truly believed in what I had learned, and that was where
Right.
my confidence
Yes.
lay. And I was really determined because where I really believed it, I was thinking this must be right. And the only way you'll find out is if you go to the fire pit and try and stand your ground. So when I did get the first what I call agreements, by not standing up and him accepting, because when I did the Mister, he didn't really argue with me after that. When I said the property about my daughter, and I did, I'm he who creates, benefits, and maintains, which are the elements to property. He ultimately agreed with me. So that really gave me a lot of confidence that I was, oh, okay, I'm saying the right stuff.
Yes.
Although I don't
Uh,
really know what to say, like completely, what I did learn is coming true.
yes. And the fact that you were using those terms, which and again reading the transcript, which is really interesting, where you said, "Well, I'm talking about my property,"
Yeah,
and he comes back, doesn't he, and says, "Well, that's not very nice way to talk about your
yeah,
daughter," or
yeah,
words to that effect. But he knew exactly what you were doing.
yeah. Because they usually test you three times. There's a rule of three. So
Right.
um, he said when I said property, he's like, "Your property? You mean your daughter?" And I think daughter is a word you can use, but I was just adamant. Let me just stick to property.
Yes.
And then he accused me of using strange language. So then I had to learn how to like make him listen. So I understood. Okay, you have to bind a judge to what he's ruled by. So I said, well, by law, judge, it's considered property based on what I express with the elements to property. And he said, oh yes, you're correct. I was thinking, oh,
Yes.
oh my God, he agreed with me. Like, oh my God, he agreed with me.
Yeah.
So I was a bit taken aback, and I was, oh, okay, what do I say next then? Uh,
Would you say that when you're in that situation and you are discovering that stuff that you've theorized on that you deeply believe, but you haven't had the experience, as you go, there would be a point where you could become too cocksure and make mistakes, where
yes,
your
yes,
confidence gets too high.
yeah. Like I was fortunate because it was a 3 day event. So the first day, I managed to get out quickly because it got adjourned because I didn't get a chance to see the applicant's paperwork. So you have to have like a 14-day window to be able to see anyone's paperwork so that you can create a defense. Now, if you don't
Right.
get to see it within that window, you can ask the court to adjourn it. So I did understand that. So I did actually seek for that. So then the next court dates were, about 6 months later. So I went into real practice mode because I had a few of those checkpoints actually confirmed. So I think, oh my God, like this is true. So let me
Right.
delve into learning like what I need to say. So I started just focusing on what a judge needs to hear because he's the top guy and nobody else really matters and he makes the decision. So what is it that I need to say to him to be compelling enough that he goes with my truth? Um, so yeah, I just did lots more research. But so by the time I was in the second and third day, 6 months later, I was actually quite confident.
Right, and that's so useful, isn't it? That you've got that time period. I mean, the chap I interviewed the other day about trial by jury, he said that when he eventually got this so-called trial by jury, which actually sounded like a jury trial in the end, but it it was set for a year later, and I thought, well, that's useful because you've got time to hone your skills for that moment of that bit of theatre land that you have to go through, but. This was a high court that you went to.
Yes.
So how did you get your case from the lower court, or was it straight into the high court?
No, it was at the county court. It went to the county court, then the district court.
Right.
So this kind of happened around COVID. So it was virtual hearings.
Oh, right.
At the county court and the district court. This was before I found the information that I found. So I was just going on my own, logic, let's say.
Good for you.
The thing that got me through them is a court cannot make a determination if they can't achieve understanding from all parties. So everybody has to show that they understand what's gone on today, and then they can make a determination. So I actually lacked understanding through the whole way through, mainly on the actual argument that, well, this is an agreement that me and the mother made. So why would we be now going to court for residency when we've already established, residency technically privately? So, and where that was my, we'll call it argument, that was my position, let's say. So where I just stuck to my guns and said, well, I don't understand why you're telling me this when the judge is suggesting stuff. At the district court, the mum was in another country, and the judge told me, oh, I should wait until she comes back and then send my daughter back to her. I was like, well, why would I do that? That doesn't make sense. Yeah. So they got fed up and it's, oh, well, we're going to have to send this to the higher court because we can't decide. And so that's actually how it got to the next court, and ultimately the high court, through the lack of understanding.
Through the lack of understanding, yeah. So, okay. So if someone was doing something similar, they could use the lack of understanding to keep escalating it up.
Yes, but I realized that family court, it doesn't need to get to the high court most of the time. This is why I wrote the book, because I wanted to share that it was a lot simpler than I had thought. It wasn't. I went in on a different ground that most people, I wouldn't recommend going on this ground, trying to not give jurisdiction. I did that because I found the information. I was in a certain point in my life, and I just came across that side of information. Coming out of it, I realized that judges are mostly quite fair with child arrangements. Most people go to family court for child arrangements. It's the biggest thing. It's either divorce or child arrangements. Divorce is just about assets. That's a separate issue. What we did, we're focusing on child arrangements. The judge, they do respect that they have a 50-50 equal responsibility, and they do like to stick to that. So that, that's what you combine them on. The only reason why they don't give that is if there's any fear of any harm or injury to the child, as expected.
Yes.
So knowing that, I would recommend most people going on the legal grounds.
And you make that blatantly obvious in your book. And whilst you mention that, I mean, you talk about your case, which is absolutely fantastic and encouraging to anybody who sort of follows common law, because you can see it being enacted and you think, wow, go, Dane, go. But then the second half of the book is really, really useful stuff for those people who are in that situation where they're perhaps fighting for who's going to have the child, and you've got all the places to go, processes to follow.
I put
navigating.
I put literally the legal framework of what you would need to understand, because if you understand the legal framework, you understand what the judge uses to make his decisions, and if you can understand what the judge is going to need to make his decisions, you can hone your paperwork or your argument to that type of grounds. And that's kind of what he needs to follow. So it's why not follow what he needs to follow? And I just focus on presenting. A lot of the court issues is presenting it the right way. And that's what I really learned. If you present your case in the right way, it creates a much more compelling case. And
I think what you said at the beginning about, and you say it in the book several times, you're honing everything so that it's for what the judge understands or needs to hear.
Yeah.
Rather than getting lost in all sorts of sort of petty arguments. Once you know what the judge needs to know to make the decision, hopefully in your favour,
Yeah.
you're basically targeting that, which I think is something a lot of people don't really consider. People assume the judge will make the right decision or that they're fraudulently there anyway. But if you're able to sort of go, I'm going to make this as really easy for the judge so that it's a
Yeah.
no-brainer.
Because ultimately, the way the court works is you're meant to go in knowing knowing which court to put your application in, know what you want to say, knowing how to present to the judge. So ultimately, you're directing the judge, not asking him. And
Right.
I wanted to show people that mostly with child arrangements, it's quite you can do it yourself, and it's not that difficult. So save your money on a lawyer because they're really expensive, and sometimes they're the ones that drag out the process.
Yes.
I don't think it really takes that long to deal with child arrangements. You've got a structure, they've got a structure, you meet a middle ground structure. If there's any issues, you present that. You have to give it some basis, so present it with some fact. Otherwise, it might be speculation, which is really logical. So, I'm just trying to share with people. I guess most people fear that they've never been to court. It's scary. Oh, I don't know how to write a court document. So in the book, I've presented, how I wrote court documents, how they look like, the different headings or where you put your writing, how you present it. Um, to hopefully show, well, this is how you present it. Once people actually look at that, they'll realize, oh, actually, I know how to do that. So all I've got to do is then post it to the court and then turn up and express this with my voice.
Yes. Yes. And you don't have to do the common law approach, as you say, because that instills a lot of, hang on a minute, am I ready to keep fighting off the jurisdiction? You can follow the legal practice. And because if your argument is that strong, then it should follow that we would win.
Yeah. And if it's mother versus father, what I did realize in taking the common law approach for mother versus father is the judge actually taught me that everyone has the right to access their children. So if I got him to discharge the case on the grounds that I'm winning on this private side, this is my property. Like technically it's her property too, and she has the right to see her own child. So he couldn't allow me to win. Well, if I didn't give him jurisdiction, she could just keep reapplying because I can't give him jurisdiction that she can't keep coming back for this situation because everyone has the right to access the court to see their children. So I realized that if you're doing mother versus father, then don't bother with the common law route because it doesn't make sense.
Right.
I would use the common law route with if a corporation's coming after me, like the guy who helped me in America, it was the CPS for him, the child services in our sister services, or anyone else, any corporation come for you. That's when I would do the common law, no jurisdiction over my property.
Yes, and I think that's worth underlining there because what you're talking about in the book is between a mother and a father, just agreeing on who's looking after the child. But when you get organisations, as you say, corporations suddenly becoming involved, like the CPS, that's a different animal altogether.
Yeah, exactly. All the social services, they're not people. They're entities.
Yeah, no, exactly.
It's not a real individual. An entity can't come for your, children. So the argument is this is my property. You don't have the right to interfere with it because that's what that's what you would accuse them of, interference of your right to property.
Yes,
That's a real claim in a court.
Yeah, quite right. So anyway, so the book is available and it's on your website. I haven't got it immediately to. What is your website?
My website's www.lawbydejure. That's LORE by BYDEJURE. So law, LORE, comes from folklore. People might recognize folklore. Folklore was, the customs known to that community. It was, the kind of knowing law. You don't cause loss, harm, injury, or damage. Pretty much, which is kind of natural law in the same way. So that's the law, LORE. So I kind of reflect that in the name.
And de jure means by right, doesn't it?
Yeah, de jure means by right and authority.
By right and authority. So, we'll put the link to the description so people can go and purchase this book. But now that you've become this wonderful author, and in common law, I mean, there isn't enough books I mean, I have to say, people ask me all the time, where can I read up about this? You know, the internet is one thing. And as you mentioned before, there's myriads of websites and YouTube videos, and they're all good and they've all got bits of information. But sometimes you just want to sit down and focus on from A to Z of a certain topic within common law. And it's very difficult to do that. So you're working on other books which will be available.
Yeah. I've got one of my next book's come out. It's called Hidden in Plain Sight. So
Hidden in plain sight.
through the family law issue of not giving jurisdiction, calling me the Mister and saying I'm not a Mister.
Yes.
The next book identifies that these are capacities that you take on. Mister, Mrs., respondent, driver, citizen. These are all roles that have a persona to them, and if you take on that persona, you take on that capacity, and all of these capacities and personas are legal. Therefore, you have legal liabilities and duties that come under them. So the next book is to separate the fact that here's what you might be considered in the realm if you act in these capacities, and here's how you separate yourself, i.e., in private capacity, and use language, use a concept. Like I said, they have their version of how events go, and I have my version of events. They use certain words, and I use different words.
And that sounds really interesting. I'm looking forward to reading that one because everybody, I mean, a lot of people say to me, "Oh, hello, Mr. Vobes," and
Yes.
you think, well, hang on a minute. I haven't said that I'm Mr. Vobes. I just say I'm Richard Vobes, and I know that is a name, and it's often in capital letters, etc., etc. But it's when people sort of address me as Mr. and you think, well, where did that come from? I don't tell people that's who I am. As you mentioned, your mother never put that prefix to your name. and we're taught to do this at school or when we get something, it just happens. And then it's from a Mr. So-and-so. And so you write back to Mr. So-and-so. And so we become so subliminally used to using these terms. One of the things that is not in fashion so much, but when I was growing up, was I would get letters to me say, Richard Vobes Esquire. And I never really understood what that meant because I thought, what do you mean Esquire? Am I the squire of my own domain? And I just wondered, have you come across that term?
Not Esquire. One term actually that you might find interesting is the Bill of Rights. I use it quite a lot in other areas, but in the opening, it says it basically says that Parliament's here to represent the estates of the people, i.e., not the people, the estates. And later on in the sentence, it says William and Mary, Prince and Princess of Orange, appear in their proper persons. That's the way they are referred to. So your proper persons would be your private capacity.
Right.
And that's proof, that's from 1688. For me, that's proof based on what I've learned that that's the way you can, that's proof that there is a private capacity.
Yes.
And that's
because you've been separated by proper persons as opposed to person, which is a legal entity, a corporation.
Yeah.
And obviously your name is associated to that. We've all done the birth certificate business and all of that. So that's really good. And I believe I'm right in thinking that you've also got another book on the dealing with council tax and that sort of thing.
Yeah, so I went through that process. I learned it. I went through it. So I decided, I've helped a few people. I've decided that I just put it into a book, and then I don't have to keep repeating myself.
Yes.
And then the book people is the process that I followed, and I got some. Again, I got some evidence that now allows me to sit in somewhat comfort, knowing that they can't be true because I've got this evidence, and logic says that my evidence is more right than theirs, than what they're saying.
Yes.
It's called it as demand and obligation because I'm not trying to say you do or you don't have to, or this isn't how it is. It's everyone's truth is their own truth. So it's just a reflection of, again, my first-hand experience of, how I dealt with it, what my findings were, what my outcome was, and little bits of evidence or tools that I managed to obtain that allow me to feel or be comfortable in that, I must be right. And if somebody does take me to court, I'm going to present this evidence, because you write back to these people, you send notices, and the key to sending all these notices is they act as your evidence if should someone take you to court, or should you need to take someone to court. So my whole family law issue just taught me that we're meant to know how to use courts, and once upon a time we all did.
Mm.
We've just been distracted from knowing how to remedy ourselves. So I'm trying to share with people that learn how to use a court. It's actually not that difficult. There's just a few forms. The only other thing you've got to focus about is what you're saying and how to present it. So now I sit in the space of, if I've written to someone, why would they pursue me when I've not refused to pay? I've not
Mm.
created controversy anywhere. So why would you pursue me? And if you do take me to court, I'm going to have all of this paperwork that I've asked you certain questions. So if we get to court, the judge is only going to make you answer my questions.
Well, exactly, and they don't want to do that.
Exactly. So then again, it's just understanding a little bit of a due process of law in terms of how the court works, what you should expect them to deal with it,
Mm.
versus if I've wrote to somebody, you should really reply honorably and in substance, like anybody would.
Yes, absolutely. The thing is, we do know with the councils, of course, and there is so much evidence out there, even from the court tribunal service themselves, that the courts are not proper courts, that they're hired by the council, that they send out fraudulent summonses, the liability order is not signed, and we now know that the bailiffs have problems collecting if they don't have the correct documentation.
Yeah. So
Uh,
in my book, I do have the notices to the council and to the debt collectors that gets passed to, and it's got the winning argument, it's got that argument of the case law. So you could actually use those notices to file your own claim if they continue to pursue you, and you get an easy win because in the notices it's spelled out for them of what they need to provide you with.
One thing that's always worth noting, I think, and something that I have learnt is the templates are great because they're a good starting point, but you really have to understand what it is you're doing rather than, because I get so many people just saying, oh, can you email so and so? I just want a template so I can just basically have a quick fix. And if you don't understand it, you won't know how to respond if they come back and ask dodgy questions, or if you end up in court and the judge asks you, or the prosecution asks you a question. You do need to understand the process enough, don't you?
Of course, yeah. I mean, I would never advocate sending something out you don't understand why you're sending it out, because if somebody
Yes.
sends a reply, if you don't understand what you're doing, you might believe that reply. You might, a lot of it's built on fear, and
Yes.
we're going to write back to you to build fear in you, to make you question yourself of if you're right or wrong. So kind of like with the family court, you really have to understand why you're doing what you're doing. And if you don't, I wouldn't advise you do it until
Yes.
because when you understand something, you gain the confidence. It's the confidence that comes through in the end.
Absolutely, and I suppose when they see that you're confident because you're able to respond to them quickly, efficiently, and with substance, that they realise actually you're not going to be just the sap that's just going to eventually crumble and pay up or go to court and fall apart.
Yeah.
And so that's very important. I must ask you this: you're a young man. And I have to say, and I did say this to you before. I mean, when I read this, I did think, oh, I didn't expect you to be quite as youthful as you look. Maybe you have some special face cream or something, because the book is well written, it's well constructed, it's a very well book, and I would thoroughly recommend people getting it. Definitely, I've read it, so that's my recommendation. But because you're a young man, I would love to know, how do your contemporaries, um, do they agree with you? Do they get into the common law? Can they see the same things as you see?
Yeah, so I'm quite fortunate. My circle of friends, there's about five of us. We grew up together, and we all have a very similar way of thinking. Obviously, we all think differently, but if you ask
Yes.
us a question, you'll get a similar answer. So we're on the same
Right.
perspective of things. Um, so they know what I'm like. I'm quite determined. I really do my due diligence, especially with these things, because you can't get them wrong. So
No.
um, they was really interested in it. The way I say it is, if you can present your argument to a layman and it makes so much sense that they understand it, then you've probably got a good case or position on your hands. So they understood what I was coming from. Now they know lots about family law and just law in and the private capacity, and
Yeah.
how to pick up on certain things. So
And that must make, I mean, legalese is so complicated. Whereas when you start talking about common law, it's basically common sense. It makes sense.
yeah,
A lot of it is innate anyway.
yeah.
And so presumably they sort of have accepted that very easily. Do you think other young people, if it was explained to them, you mentioned before that we used to learn this sort of stuff, do you think that they would get it nowadays?
It's hard because I only really got into this because I was in a situation, and most people do get into these things because they do have a first-hand situation that they're trying to deal with. Those kind of things. Um, it's you have to. I think you have to want to know this.
Right.
For me, it was a lot from COVID. I don't know what people's feelings and thoughts are on that, but I didn't want to, take that. And I understood they was trying to restrict us. Through what I learned, I did understand that this was only guidance, and I thought to myself, well, if I'm going to be doing X, Y, and Z, then police are going to approach me. I need to know what to say to them. So
Right.
that's what got me into learning. I started learning. Everybody's argument is, I'm here to do my job. So I think, okay, great. Let
Yeah.
me be the guy to learn what your job is, so then I can bind you to your job, just like I learned how to do with the judge. So, Mr. Officer, you're here to deal with criminal law, which is any crimes or breach of the peace, so or a contravention of common law. So, if a police officer comes to me, my first thing is there a crime being committed? Because that's your jurisdiction. So, the
Yes.
whole stuff wasn't their jurisdiction, and I got stopped, and got questioned, and I took away my presumption of knowing. They want you to think, oh, you know what's happening. So I said, what's happening? You explain to me. Oh, don't
Mm.
you watch the news? No, I don't watch the news. I don't think it's propaganda, but you explain to me if you're saying it. So then he's saying what they're saying. I just reminded them that they're here to do their job and they're not ignorant to their job, i.e., criminal jurisdiction. This is a civil jurisdiction. And I just said, you do know you're acting outside of your jurisdiction, which could bring a claim against you. I'm not trying to do that, but I just let you know if you're familiar with your job and you're not ignorant to it, then you should be aware that this is not your jurisdiction. And if you're not aware of that, then I can't trust that you know what you're saying. A quick little spin to get them off my case. Eventually
Yeah,
they said,
absolutely.
well, "You have a good day, sir." So that's what got me
Yeah.
into it, and that's what got me determined to learn what is it that I need to defend myself with, because the law is the one thing that most people don't know, and the one thing
Mm.
that they can control you by.
Yes, absolutely. And I think the big takeaway there is that you said that you bind them to their job. If they are an corporation employed to do something, then that's the limit of their scope.
Yeah,
And exactly as you said, you bind them to that so that they can't step outside of that and make. And if you're ignorant
yeah,
of their scope, then of course you're vulnerable.
yeah. So if you're acting in a capacity or doing your job, you're under liabilities and duties. The member of the public, or i.e., the private capacity, is the most protected person in society because they're not bound by anything unless they've done a wrong, harm, injury, or damage. So if you're
Right.
doing anything wrong, why would you be under fines or forfeitures?
Absolutely. Well, there you go. I mean, it's very rewarding for me to speak to. I know I've made a point of this, but it is a true thing. It's very rewarding to speak to a younger individual who's obviously a bright spark, knows what's going on, which is great because it gives older people like myself, who I meet lots of when I'm doing talks, huge hope that more young people, because it's ultimately this is your future, and if you're able to bind some of these overzealous
Yeah,
officials to their jobs and say, hang on a minute, this is where your job ends and
yeah,
this is where we part company, it gives us all hope. And we've seen lots of tyranny, lots of
yeah.
nasty stuff happening.
Governing's
And
governing's getting stronger. That's the thing. Since COVID and stuff, the governing's getting stronger, where they make you feel you have to do what they say, and
yes,
people believe that legislation is law, and that if they make a legislation, you have to follow it. Um, and I just wanted to show people that that's not true. The Coronation
yes,
Oath Act is the act to actually look at the King swears three oaths. To protect statutes in Parliament, laws, and customs, separating that laws are different to statutes in Parliament. So I use these acts, to remind if I do ever need to remind them, because governing's getting stronger. So you need to learn how to navigate outside of their governing,
yes.
especially when it's made up stuff. I'm not saying break the law. Of course, I don't. I don't break the law. You know,
No,
it's just
no,
that tyranny you talk about.
yeah. Well, this is, I was going to say, please keep writing because you write very well. I think you found a vocation. And this is an area, as I said before, we need more easy to understand, easy to digest books to
Yeah,
help people, because many people have been put into that position where they don't have time to go and do all the research. But if they can have a series of books where they can learn this stuff and then just bind these authority figures to what their job is, or to push back against tyranny, then that would be great. I think you've got like it or not, you've got a
thank
great
you.
great future doing that. So this book that is available, and here it is, and this is a hardback version, but I think there's a paperback version and an ebook version, if I'm correct.
Yeah, this again. I realize some people like to read physical books, so I made the
Yes.
hardback version and the paperback. And the ebook is obviously it's really good for the ebook because if you are needing the templates or some of the information, the nice thing about
And
the
links is, I mean, that's the other thing, because you've got links to various
yeah,
places
I've
in
got
here,
some
and,
links to
and of course,
certain
when it's in a hardback book, it is laborious to copy that. So that's where an ebook is very useful, because you can just click the link, especially
exactly
if it's YouTube links where it's all just gobbledygook.
yeah, exactly. It's got the links, it's got the templates. Just easy for you to just kind of use as a template for yourself. It's got a real
Yes.
life example. I've helped a few people since. So I've used my concept of law. I've helped somebody in a housing repossession
Have
where
you?
I stood as the Mackenzie friend for their mum, and her and I led led the kind of argument of how my approach is. It's just the presenting yourself. So I led the way that we would present the position in X Y Z, and she won. So she kept the house.
That's that is fantastic.
Yeah,
I suppose you mentioned earlier that you had the phone call with this guy online, and you were able to role play
yeah,
bits. I'm to build your confidence in that. I guess that is quite essential, isn't it? To be able to find somebody to role play and have arguments thrown at you that you're not
yeah.
expecting.
Because he had done this before him. He had done it for himself with his own children. So he had the
Right.
so he was teaching what he firsthand did. So now that I have the first hand, this is not legal advice, and I'm not
No,
here to give legal advice, but it's just a lot of people like to learn from people who have done stuff or doing things because
absolutely.
that's the real way it
It
goes.
gives more credibility to it.
Yeah, so I just want to share that. I feel like I have a good way of simplifying things that come across complex. Um, so just
And that's
sharing the way that
yeah.
we did it.
Oh, fantastic. Well, Dane, it's been lovely to talk to you. Thank you so much for coming on the show.
For having
I'll put the links in the description. Just a quick word on those links, ladies and gentlemen, because of the way YouTube have been treating the channel. The links aren't clickable, so you have to copy them and paste them into a browser. It doesn't matter how many times I actually say this, but people will come back and go, your links don't work, Richard. No, it's because they're switched off as links. They're not. They're just
Oh wow,
they're just yeah. So copy and paste them into your browser from YouTube into a browser. It's not difficult, and then it should work. And sometimes if they're very long links, I have to use what is it, tiny URL to do it, because YouTube will cut them off. It is a very strange world we live in, but there we are. It's a free platform for me to use. I'm demonetized, banned 4 times. We're doing the best we can, so be kind. But there it is, The Family Law Layman's Guide, and it's a beautiful book and very well written and worth a read, even if you're not into family law, because it gives you the transcripts and it gives you a sort of basis on common law, and then a whole load of other sort of legal bits and pieces as well. So, Dane, thank you so much for that. I really enjoyed it, and it's been fun talking to you as well.
yeah, likewise, likewise. Thanks for having me. I hope
It's,
people, yeah,
uh,
just hope you enjoy the information.
no, appreciate that very much. Well, there we are, ladies and gentlemen. I hope you enjoyed that. It's been good fun. I'll be back with more monologues and more wonderful guests. But in the meantime, I'm going to send Dane off to write some more books. Hope you don't mind.
No,
Um,
no.
and I'll be back in the future. Meanwhile, from Dane and I, thanks for watching. Goodbye.
Bye bye, everyone.